Justice Deepak Gupta, to you, I begin by asking what you make of the Law Minister's comments today. Once again, raising this issue of judges, their appointments at this public event, saying that judges do not, face public scrutiny the way politicians do, but that the public is watching.
Yeah. I think, first of all, this is not one odd statement today. It is a series of statements, not only by the Law Minister, but by other high functionaries. And, in fact, I've written about it, that it seems to undermine the independence of the judiciary, the independence and the strength of the judiciary. But that has not happened. Maybe they're rocked by what the Collegium has done and, put out in the public domain what you pointed out, the various factors which had weighed with the government for rejecting names. Having said that, everybody is entitled to their point of view, and some people can say that, yes, the legislators are elected, parliamentarians are elected, whereas judges are not. But that is the way we have chosen in our constitution the judiciary to be. Unlike the American judiciary, where at the district level a lot of people get elected as judges, when the constitution was drafted, it was felt that judges should not be elected, they should be judges for long. And there are many, and in most countries, judges are not elected, especially to the highest courts. And therefore, I don't see, this is no argument actually. This argument is without any basis that we get elected, so we represent the voice of the people. See, this bogey which is being raised about the will of the people, I think let it be made clear that even the ruling government does not actually have the strength in numbers to say that it represents the will of the people. We have the first past the post system, and in that sense they have been elected according to the constitution to govern the country. But they can't say they represent the will of the people, because as I read today, they've only got 37% of the votes polled. And if you look at it in comparison to the entire electorate, it would be approximately 25%. So you have the support of 25%. Further, we never go to elections on these issues, whether the Collegium should be there or not there. This is never an election issue. I mean, I don't see how the will of the people comes into this play.
Can I ask you, because this is very important what you're saying, and you're not holding back clearly. I can see you're being very forthright and blunt on this. But before I come to the merits and demerits of the Collegium system itself, as you said, you don't see Kiran Rijiju's comments as being a one-off. Clearly, there have been a series of them. The Vice President has made them. So, there is something more at play here. What do you think that is? What do you think that the government wants to do? Do you think they want to bring in a new law to deal with judicial appointments? Are they testing the waters? Is this a trial balloon? What is it?
I think they're testing the waters. They're also testing what the public feels like. What's the reaction? Will the court sort of cave in and sort of agree with them? Sometimes you had NJAC, then you had this, why can't we be part of the Collegium? Though I think the Law Minister later clarified that it was never an intention to say that they should be part of the Collegium, but they wanted an entry and to discuss matters. In fact, I am not too much against that, where the government representative, maybe the Law Minister or any other representative, sits with some members of the Collegiums and discusses names which are controversial. You can't have a discussion on every name. If the government approves, fine. If the government sends back a name and the Collegium reiterates, then there could be a discussion. I don't see any reason why, because there are many things, Nidhi, which cannot be said in writing many times. When you are appointing people to high offices like judges of the High Court and the Supreme Court, sometimes you don't want to say things in writing.
It's interesting you're saying that. You're saying that this can in a way be a meeting point where the government doesn't have a formal role in actually appointing judges in that sense, but you can have a more sort of a discussion when there are names on which you're stuck. But ultimately you're saying the Collegium should prevail, as it does now.
The Collegium must prevail. I mean, as it is, the law says the Collegium must prevail. But when we talk about improvements in the Collegium, sometimes the government has objections, the Collegium accepts those. But like you saw, this time one of the objections was that one gentleman had shared an article which was critical of the Prime Minister. I'm sorry, even if he had written an article critical of the Prime Minister, that does not make him ineligible to be a judge if his competence, his integrity is otherwise beyond doubt.
So, can I ask you, sir, that on this issue of the way the Supreme Court responded to this, as you mentioned there, and I mentioned at the beginning, by making public these intelligence reports on, candidates for High Court judgeships, etc. One of the arguments that has been made is that this was a good step because it brings in transparency. It makes it clear to the public why certain appointments are going through and why others are not going through, but that it cannot be selective. That therefore, if this is going to be the case, it can't be that the Supreme Court Collegium was just trying to make a point with a few cases last week, then it should do this consistently in every case. Would you agree?
No, I agree. You see, there are two levels. When the Collegium sends a name and gives reasons why sending a name, or even if it doesn't give, and the government sends back the name, and the government would naturally give some reasons for sending back a name to the Collegium. If the Collegium, if it has to reiterate, it must say it has reconsidered the opinion of the government and the objections, and it feels they are valid or not valid. I see no harm in this. And it should be a consistent practice as far as possible.
Can I ask you, Justice Gupta, we have Justice R.S. Sodhi, the retired judge of the High Court, whom the Law Minister had quoted. In fact, Justice Sodhi will be joining us shortly as well. He raised the point that he believes that the collegium system is unconstitutional. He believes there should be a secretariat in high courts and the Supreme Court to appoint judges. How can it be that some judges get together to appoint judges is the point that he's making. On principle, wouldn't you agree that the system needs a complete overhaul? Is there a way to do it more transparently without necessarily giving the government a veto on appointments?
There are two aspects in this question. In what Justice Sodhi has raised. I've unfortunately not seen his interview. I've just read what has been quoted in the newspaper, so I may be wrong. One, he said it is not in the Constitution. He is right to that extent that in the manner in which the Supreme Court has interpreted it, it's not in the Constitution. But if we look at the three judgments in the judges' cases, what was weighing with the government was what had happened earlier in the 70s, when the government ran roughshod and superseded some judges. So it was a reaction that we want to have, and I still feel that the judiciary should appoint, and I still feel that primacy should always lie with the judges because they're the best suited to both select and assess the integrity of the candidates. But as Justice Sodhi points out, there are certain difficulties. I have also been a great votary that there should be permanent secretariats in the High Court, in the Supreme Court Collegium, as well as the Supreme Court Collegium, which have the background and the entire history of all those people who are likely to come to the Supreme Court or the High Court concerned. So all old complaints, all the good judgments. So you have, it's not that one day a name comes from the High Court and you see. My other issue, a very important issue, Nidhu, which has not been considered almost by many times, the Supreme Court rejects a name sent by the High Court. It has happened to certain names which I sent as Chief Justice of the High Court, and I had to convince one or two of those people with great difficulty to give up lucrative practice to accept office, and their names were rejected. And I never found out the reason why they were rejected. I think there should be a dialogue between the Supreme Court and the High Court also, that you've recommended this name, we are not agreeable to this is our view, what do you have to say? It just can't be that you just say, we don't agree and this name is not being.
No, absolutely. And in fact, we've had former High Court judges on this program only weeks ago, quoting exactly the example that you gave, with this feeling about a lack of transparency. But Justice Deepak Gupta, where does this confrontation go from here? Because it is rather worrying to see it. We are the world's largest democracy. To see this kind of confrontation between two big arms of our democracy. How do you see this ending?
I think I agree with you. Though I've always said that I always like a little bit of friction between the government and the judiciary. It shouldn't be too well oiled because then that becomes dangerous.
It's more than a little friction, though.
But this is not just a friction. This is becoming much more than a friction. I agree with you. But having said that, I think things will resolve. I have hope in this collegium which is presently there, that they'll stick to their stand and they'll not be cowed down. Because I have a feeling that the government is just testing waters and saying, well, will the collegium cow down or the Supreme Court? It doesn't appear to be happening. And somebody will have to step back a little bit. 1 or 2 days back, we saw stepping back by the law minister, but yesterday and today, he's made some other statements. And he's right. I'm not saying that the law minister is entitled to his point of view. Justice Sodhi is entitled to his point of view. I am entitled to my point of view. But if there has to be a different point of view, this shouldn't be a slanging match and in the media. It should not be taking pot shots in the media. If the law minister has any difficulty with the system, he should write to the Chief Justice. He should seek an appointment, or they can both meet, sit together and say, these are the issues we raise, and let's see what has to be, how do we go forward? You see, problem, Nidhi, is that we look at our personal interests. If all of us, whether it be judges, whether it be politicians, whether it be lawyers, if all of us looked what is best for the institution, what is best for the High Court concerned, what is best for the Supreme Court concerned, and merit is taken into consideration, obviously in the context of diversity and giving gender equality a proper place. If you look at all this, I don't think there should be any place for confrontation.
Can I ask you?
But if you look only at merit, the problem becomes when you're not looking at merit and you're looking at other things. Then there is a problem.
If I could ask you a somewhat, how to put it, maybe a sensitive question, which is that is the higher judiciary and the Supreme Court in particular partly to blame for the position it finds itself in today vis-a-vis the government? I'm asking this not just because of the way judges are appointed, but because of this perception that the Supreme Court is not taking up sensitive matters that could make it awkward for the government, whether it's electoral bonds, Article 370, other such cases that should have been settled a long time ago. It took forever for the demonetization verdict to come. There are questions about how a former Chief Justice of India retired and immediately became a Rajya Sabha MP. So has the judiciary...
I'll not get into the law.
No, but I'm not saying specifically this. I'm saying that has the higher judiciary in a way... in a way got a little compromised over the last few years, to be very honest, with all due respect.
I won't say compromised, but I've always said this and I repeat here today, that the Supreme Court has two roles. One is that adjudicator of disputes, which has been doing quite well, but is also a protector of the human rights of citizens. And in my opinion, well, they've lagged behind a little bit or a little more as far as being protector of human rights are concerned. I mean, the issue of the taking away Article 370, why should it hang fire for so many years? It's a small issue as far as it is legally concerned. But one way or the other, once it is decided, it will settle what is happening in Kashmir. Then the other big issue, as far as for me is concerned, as far as Kashmir is concerned, is whether a full-fledged state could be bifurcated into union territories. And you take away the right of statehood from the state. It's like, we have a concept almost like a dual sovereignty. The union is sovereign and the state is sovereign. That is why we have different lists in the constitution. One is the state list, one is the union list, and one is the concurrent list. Now does the union have the power to denude a state of its right and turn it into union territory? That's a very important question. These need to be decided. Habeas corpus petitions pending for years on end. Electoral bonds. I feel the Supreme Court should be deciding these matters, and I have great hope that under the new leadership, Justice Uday Lalit started the process, and I'm sure that under Justice Chandrachud this will move faster, and we'll have decisions on these cases also.
All right.